Hello and welcome to Chetan Bharat Learning, and in this class we're going to do current affairs for polity from 20th of this month to the 27th of this month. Alright, so let's begin. What are the issues that we're looking at in this class? The first and foremost is we're going to understand what mercy petitions are and why the law on mercy petitions is something we should take active cognizance of. Alright, and the second issue that we're going to look at is the borrowings, right? Whenever a state government borrows, what are the constitutional principles involved? Although this is one topic that you're going to do in your economy also, hopefully. But in this class, we're going to look at it from a very constitutional prism and try and understand what issues of fiscal federalism dawn upon this issue, all right? And the third issue that we're going to look at is Adhaar review petition. There were a bunch of petitions against the 2018 Adhaar judgment by the Supreme Court. Those petitions have been dismissed. So we're going to look at this case. We're going to look at constitutional provisions. We're going to look at the Act, the Adhaar Act, and we're going to look at the Adhaar judgment, right? The original Adhaar judgment, and try and get hold of the issues involved. So this is a very important class that you must pay acute attention in, all right? So let's begin with mercy petitions, all right? So what happened was that in the Supreme Court recently, the Solicitor General assured the Honorable Court that the governor is going to decide on the mercy petition based in Tamil Nadu within 3 to 4 days, right? So there was an assurance provided by the Solicitor General. So let's understand the background for this. So what happened was that a pardon request was moved by the convict in the Rajiv Gandhi assassination case in 2015, right? The Supreme Court pretty much said that in September 2018, the Supreme Court said the governor is deemed fit to decide on the petition. So the burden for decision came upon governor, and it's been pending since September 2018. And then what happened was that a recommendation was made to remit his life sentence, and this was advised by the state cabinet to the central cabinet under Article 161, all right? By the state cabinet to the governor under Article 161. However, the governor's decision is still pending, right? So it's been like a very long time since it's happened, 2018 September, all this way, right? So there's considerable amount of delay. So what is the central government's argument? The central government's argument is that the pleas for pardon or should go to the president instead of the governor. And why? Because the case was being investigated by a central agency. So you should sort of look at the pressure points on the governor. One, the pressure is coming from the central government saying that the petition should have gone to the president. The court is asking the governor to decide, and the state government has recommended to the governor for a mercy petition, right? The state government has recommended the decision. So what is the petitioner's argument? The petitioner is saying that the convict is free to choose where he lodges the mercy petition, right? Whether it is with the president or the governor, whose decision it is. It's the decision of the petitioner and not the government, right? So the petitioner in this case also referred to the very important constitutional bench judgment in Union of India versus Sriharan in 2015, where the court said that the exercise of executive clemency, which is the grant of pardon, the power to pardon, is vested in the president or the governor. So it's either, right? So you could send your mercy petition to either the governor or the president, and in this case, the convict under the Rajiv Gandhi assassination case had sent his petition to whom? To the governor. So it's fit for the governor to decide, and that's what the court also held, right? So the centre in 2018 rejected the Tamil Nadu government proposal to remit the sentence under section 432 of the CRPC, right? What happened was that the state government recommended to the central government that you should remit the sentence under section 432 of the CRPC. What does the section say? It says that the appropriate government at any time without conditions or upon conditions which the person sentenced must accept can suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced, right? So it's the decision or it's the call of the government as to whether they can suspend the sentence. All right. So the Tamil Nadu government proposed to the central government, do this, right? You could do this under section 432 of the CRPC. But central government rejected this, and this did not prevent the convict from going to the governor under Article 161, right? So what is the central government stand, this should have gone to the president, not to the governor under 161, right? So what did the court then finally observe? The court said that this delay, first of all, is extraordinary, right? This is not how it should work, and the decision was not forthcoming despite the state government's recommendation, right? Now, what needs to be noted is that the governor cannot reject the state government's recommendation, right, which is important. However, there is no time limit prescribed for the governor to decide this. So that is what the governor has been sort of banking upon in this delay, right? The governor, so what had happened earlier was that the state government recommended to the governor to remit the sentence. The governor returned the file back to the cabinet, saying that you should reconsider. The state government stood firm and said, please, like, you need to do this, and the governor is still sitting on the file, all right? So let's first look at Article 161, right? We need to understand what the constitutional provisions say. It's a fairly straightforward provision, and this is something that you do in your regular polity classes also, right? The governor of a state shall have the power to grant pardons, reprieves, respites, remissions. You should understand the differences between all of them, all right? Then the scope for pardoning, between the difference between the presidential power of pardon and the governor's power of pardon is based on two accounts, right? The first is that the president is empowered to grant a pardon under a court martial while the governor is not, and then the president can grant a pardon in all cases where the sentence is the sentence of death, while the governor's pardoning power does not extend to death sentence cases, all right? So these are two very basic elemental differences which everyone knows, whoever has gone through his or her polity class, all right? So this is not much of a scene, all right? So let's move on to the bigger point that is to be made, right? The bigger point is that the power to pardon under Indian constitutional law has been in a flux. There are multitudes of issues, right? So let's examine, right? So Article 72, which is the corollary to Article 161. So Article 72 grants the power of pardon to the president, while Article 161 does the same to the governor, right? So Article 72 empowers the president in this manner, right? But the problem is that there is this mind-numbing silence as to the factors that the president or the governor should consider while exercising his or her power to pardon, right? Now, some scholars say that because this power to pardon is an executive prerogative, the silence on the factors that need to be considered is deliberate, right? It's designed that way that the governor or the president should be free from any conditions that the constitution may impose, right? So while the legal position is clear, right, Shamsher Singh, the crowning case, right, it pretty much says that the governor is bound by the advice of the Council of Ministers, right? It says so, and that is the case law also. And Kehar Singh, which is the important case here, affirmed that position. However, a bunch of things were done by Kehar Singh. The judges went into the conditions under which such advice, which is given by the cabinet to the governor, might be unconstitutional, right? So what are those circumstances? So Kehar Singh first and foremost refers to the Indira Gandhi assassination case, right? So it might happen that the cabinet, which is providing the recommendation to the president for granting of pardon, is biased, right? Why? Because Indira Gandhi was assassinated and the cabinet at that time were from the same political party. So this created a situation where where the result or the decision of the president might be biased, right? The second condition or the second situation that was discussed in the case was that of a coalition government, where the decisions to pardon or not might be based on political considerations and not considerations of merit, right? So this was another instance. So the problem is that while the judges went into these situations and pretty much laid out what is important, like the circumstances under which the advice might not be constitutional, implicitly subjecting the power to pardon to judicial review. What the judges did not do, or what was sort of expected of them, was that they did not provide any guidelines for the exercising of this power, right? So while the judges said that in certain circumstances the advice tendered by the cabinet to the governor or the president might be unconstitutional, the judges did not provide for guidelines for exercising such power, leaving the discretion of the executive in deciding pardons very widely open, right? But at the same time, this was subject to judicial review. All right. So the basic thing that you need to understand about pardoning power is that it's a judicial prerogative, right? The assumption being that the judicial process may go awry, right? The judicial process is capable of committing errors, and to ensure that the no blatant errors they don't result in like gross violations of a natural sort of sense of a justice. That's why executive has been given these powers, right? So we know that so the implication of this being that new rules of natural justice do not apply to these executive decisions, right? So these need not be reasoned orders in that sense, right? So president or governor are allowed to re-examine the facts. They can even re-examine the evidence, or take account of any new information that might have surfaced, right? And this was the primary motive of Kehar Singh judgment also, right? So nevertheless, Supreme Court has been abundantly clear that judicial review applies to the power of pardon, and two cases stand above everything else to sort of confirm this: Maru Singh and Kehar Singh. Kehar Singh we've discussed, right? So the law of pardon, what you can figure from this, is in a consistent state of flux, right? So grounds for judicial review are not clear, right? That's what you should get out of this. Then let's move on to the Kerala borrowing case, right? So generally, this is the sort of thing that you do in your economy class. But what has happened is that the circumstances of a report published by CAG upon the Kerala's borrowing situation has significantly appealed to constitutional provisions, all right? So this makes it mandatory that we sort of look at constitutional provisions. So what has happened is that the Comptroller and Auditor General of India has published a report that said that the off-budget borrowings made by the Kerala Infrastructure Investment Fund, KIIFB, which by the way is a very like a famous entity also, right? Now it has had a huge role to play in Kerala's development up till now, right? So it said that the off-budget borrowings by this quasi-government entity for critical infrastructure projects have bypassed the limit set on the government borrowings under Article 291 of the Constitution, 293 Clause 1 of the Constitution, and such borrowings do not have legislative approval. All right. So what are off-budget borrowings? Off-budget borrowings are a tricky thing. So what you can do, let's say a state government does not have enough money in its bank and it wants to borrow money, right? But there are limits to how much a state government can borrow, right? The limits come from Article 293 of the Constitution, which give the power to the state legislative assembly to set limits as to how much the state government can borrow and how much it cannot borrow. So let's say there are limits involved and the state government really wants to borrow. So what will it do? It will ask a semi-government entity, in this case the KIIFB, to borrow, right? So this is called off-budget borrowing. And why is this done? Because this is not reflected on the fiscal deficit on the state, and this is basically not reflected on the budget sheet of the state government, all right? So what are the provisions of the Constitution that are under consideration here? The first and foremost is Article 293 and Article 292 also, right? Article 292, what it does is that it covers borrowing for the central government, how it could be done, how it could not be done. The FRBM Act, Financial Responsibility and Management Act, was passed under Article 292 of the Constitution, which places limits on how much the central government can borrow and how much it cannot, right? So the ancillary, the corollary or the corresponding provision for the state governments is Article 293, all right? So what it does is that it empowers state legislatures, as I've told you earlier. Article 293 Clause 1 does that. State legislatures the power by law to enable or limit the state's executive powers of borrowing and giving guarantees, right? So the same article, Clause 3 and Clause 4 are very important, all right? So under Clause 3 and Clause 4 of the same article, state governments need to obtain the consent of the center for raising fresh loans if they have already borrowed from the central government. So let's say there is a loan pending from the central government, and then the state government wants to borrow, then it needs to take the consent of the central government, and the central government could impose limitations upon the state governments on the conditions that it under which it wants to borrow from the other entity. All right. So this provision pretty much is the let's say the linchpin, not the linchpin right now, but very important to fiscal federalism structure in the country. All right. So what are the issues involved? The first and foremost is that the CAG report says that it bypasses constitutional limits, right? It says that the Article 293 places certain limits on what the state government can borrow and what it cannot borrow. So let's say it already has a loan pending, it needs to take the consent. There was no consent taken in this case, right? Second, whenever state government borrows, it has to adhere to the limits set by the state government's or the state legislature's laws, right, on the financial management laws. There was nothing right here, right? So this loan sort of violated those laws also, right? Then entry 37 of the list 1 gives the power of raising foreign loans only to the center, right? So entry 37 list 1, it gives the power for raising loans from foreign entities only to the center. The KIIFB violates this provision because it issued masala bonds on the London Stock Exchange in 2019 and raised some 2,000 crores, all right? Then the CAG's issue is that there was an excessive lack of transparency, right? So nothing has been disclosed in the budget documents, right? The other issue it has is of intergenerational equity, which is that if you borrow in this generation, the cost of paying that loan back is transferred onto the future generations. But that, I think, is an issue that is that applies to almost all governments, right? So it's not very specific to Kerala government. Then how does the state government plan on repaying this? So their plan is that they are going to take money from the petroleum cess and the motor vehicles tax, and that's how they're going to pay back, right? So in the end, where is the burden coming to, right? It is coming to the state government, right? So if the state government is going to have the burden of paying back this money, then it should be on the state government, then it should be openly on the state government. Their charge being that state government is using a semi-government entity to raise money, which it should itself do, all right? So CAG government report also said that because KIIFB has no source of income, these borrowings will ultimately, and the state government has stood guarantor for these loans, the direct liability will be on the state government, right? Then external liabilities is another issue, right? So under entry 33, central government has been given the power to raise loans from outside the country for a reason, because there needs to be a common entity to manage the nation's transactions, especially loan transactions with the outside world. So these external liabilities can just keep on rising and would be beyond the purview of the central government to manage this, right? Then what is this KIIFB, right? It came into existence in 1999, and its major purpose was the investment for critical and large infrastructure projects in the state of Kerala. Kerala was the first sub-sovereign government, by the way. KIIFB was the first sub-sovereign entity to tap offshore international bond markets, right? In 2019, it issued masala bonds, which are rupee-denominated bonds in foreign markets, which raised 2,150 crores on the London Stock Exchange, all right? However, what had happened was that in 2016, its role was changed from handler of investment bonds to an entity which was to mobilize resources for development projects over and above the state government's finances. So you can see that this arm of the state government, which is the KIIFB, is doing the budgeting for the state government, right? It's raising money for the state government. And this could be a good device to sort of get around Article 293, clauses 3 and 4, all right? That is the charge of the CAG. Now, what does the state Kerala government say? So first of all, it says it's detrimental to the state development, right? So it says that it doesn't matter how much loan there is. What matters is the loan to GSDP ratio, right? What you are doing with that loan. If we are going to use that loan to build public infrastructure like schools, roads, hospitals, then it is our prerogative, right? So that's their first argument. The second is unilateralism. The Kerala government says that the CAG government did not, the CAG did not ask for responses, observations, comments. It just published the report on its own. You could have asked us, you could have quizzed us as to what you were doing, right? We could have answered these questions. And the third thing they're saying is this is already RBI approved, right? RBI under the constitutional scheme is allowed to do a lot of things. Under the 1935 Act is allowed to act as agents of state government in multiple capacities, right? So this was approved by RBI, but CAG said that but the CAG has criticized the RBI for approving it actually, all right? Then the most important part of it is the federalism angle, right? So we have a federal structure, right? And cooperative federalism is where we are inching towards, right? That's the argument. So under that cooperative federalism, we need to have a very strong sense of fiscal federalism, right? A subnational economic autonomy is very critical to the federal structure that we have right now. So under that, it is necessary to provide a mechanism for regulation of subnational debts, right? So the Kerala government has said that our macroeconomic financial stability is dependent upon us borrowing, having a free hand in our financial situation. The state central government should not intervene, right? So the intervention of the central government in the ways we borrow and the ways we don't should be very restricted, right? Which is an argument that has been supported by earlier judgments also, right? So this, right, Matthew versus Union of India is a judgment by the Kerala High Court, in which it's a very important judgment, and the Kerala High Court said that you should not look at Article 293 in a restrictive manner. It is an enabling provision. The idea behind the provision is to enable the state governments to borrow. So interventions by the central government should be very restricted, right? However, in this case, the central government hasn't said much. It's the CAG that has outlined certain issues, right? Then cooperative federalism. So this is like a way forward that you need to look at. Both the central government and the state government sort of need to sit down and look at like how this is going to work, because this is not a new issue, right? CAG also raised concerns about Himachal government. CAG also raised concerns. CAG raised concerns about Maharashtra government, but Maharashtra government was also involved in dealings like this, right? So after liberalization, after 1991, what has happened is that these state governments have become such big economic players in their own right that it is, let's say, unfair to restrict them in their dealings, right? So central government under the liberalized regime that we have needs to sort of adjust to the new role that it has to play, right? So clauses 3 and 4 of Article 293 do not merit intervention on every account, and which the central government has not done so actually. It's the CAG which has not taken account of that, right? So you understand CAG's arguments and you now understand Kerala government's arguments, all right? So let's move on to the last issue for the day, which is the Adhaar review. Now this is where I need you to focus, all right? This can get a little tricky. So what has happened is that, the Adhaar judgment, right? So in 2018, Supreme Court came out with the Adhaar judgment where it upheld the constitutionality of the Adhaar law, where one of the primary challenges to the judgment was that it was passed as a money bill where it was not a money bill, right? So a bunch of review petitions were filed against that judgment, and the Supreme Court recently, a constitutional bench of 5 judges, dismissed those review petitions, saying that the Adhaar judgment was passed appropriately, right? So this is what has happened recently. However, so I hope you've understood the background here. So what is the issue at hand? Whether Article 110 Clause 3, we're going to do this article properly, whether the decision of the speaker to certify a law as a money bill, right? A bill as a money bill, whether that decision is subject to judicial review. And if that is subject to judicial review, whether Adhaar law was passed appropriately, right? So that is the question. And what did the judges hold? The judges said that there is no case for review. 4 out of 5 judges said so. Justice Chandrachud did not agree, right? So what had happened was there was this judgment in 2019, Roger Matthew versus South Indian Bank Limited, where what had happened was that the speaker's decision, the court had held that the speaker's decision was subject to judicial review, right? But that power of review is very narrow, right? So a very contradictory judgment by by Supreme Court in Roger Matthew, right? So it had held that the Adhaar verdict, the 2018 verdict, had not conclusively proved that Adhaar bill was passed appropriately. So, but then it said a larger bench would sit, because there are conflicting judgments, a larger bench would sit and that would decide. But that larger bench hasn't been constituted yet, right? So what did Chandrachud say? The dissent said that, dissent by Chandrachud said, let's wait for the larger bench, right? The correctness of the Adhaar verdict is a relevant fact, and the judges should have pretty much said that let's wait for the Adhaar judgment, as was done in the Sabrimala case, right? So there was a review petition against Sabrimala, but the judges said let's wait for the larger judgment. So in this case also, you would have waited for the larger judgment. And he further added that it would be a constitutional error to hold at this stage that no ground exists for the review to review the judgment, and it would like seriously impact judicial discipline, because there is a larger judgment decision waiting, right? However, that bench hasn't been constituted yet. So I hope you understand the story up till now, right? So what are the constitutional provisions involved? The first, so there are, under the constitution, there are primarily 4 types of bills, right? General bills under Article 107, and there is the money bill under Article 110, which is what we will discuss properly here. And there are appropriation bills under Article 114, and then there are financial bills under Article 117, right? So there is no type 1, type 2 sort of a distinction in the constitution itself, but if you go to the Rajya Sabha website and look at most of your prominent texts, what they will say is that there are 2 types of financial bills, type 1 and type 1, or type 2, or as they would say category 1, category 2, right? So there is a Article 110 of the constitution talks about money bill. The corresponding provision for state assemblies is Article 199, all right? So this is the crucial element. Pay a good amount of attention, right? So Article 110 says that if a bill contains only is the keyword here, only and only these things, right, then it shall be a money bill, right? So what there are important parts of it. For example, let's say a bill only and only imposes, abolishes, alters, remits, or regulates any tax, right, then it is a money bill. Or if it only deals with custody of the consolidated fund or contingency fund of India, payment or withdrawal from this, only then it is a money bill, right? So there are multiple such conditionalities. One condition which is relevant to us is this: appropriation of money out of the consolidated fund of India, declaring any expenditure to be charged, again being the keyword here, charged upon the consolidated fund of India, or increasing the amount of such expense. So what does it mean? It says that if a bill deals only with appropriation of money out of the consolidated fund of India, which is not the case here, or let's say even if it was, declare any expenditure to be charged upon the consolidated fund of India. So let's say there is an ideal Adhaar bill in which the only thing that is discussed, or the only provisions that pretty much effectively are talked about, is that there is an expenditure that has been rendered charged upon the consolidated fund of India. If that is the only thing that Adhaar bill does, then it is a money bill. All right. And if any question arises as to whether it's a money bill or not, whose decision should matter? The speaker's decision, right? And it is not clear whether the speaker's decision with respect to whether it's a certification of a money bill is subject to judicial review or not, because Roger Matthew said it is, right? But the scope is limited. But we are waiting for the constitution of the larger bench, right? So you should sort of understand the idea behind a money bill, right? So the constitution creates 2 houses, right? It says let the people elect 500, 600 people, and let's call it the house of the people, because the people have elected this. Let's have another house atop that first house, and this house, this house will be a house of the states, or we call council of states, where the states will send their representatives, right? So if any bill has to pass, one, the people will decide if that is the correct bill, and second, representatives of the states will decide if that is the right bill, right? And only then it shall become a law, or the president has to agree, but only then it can become a law. So the states have a say. All right, that's the fundamental principle as to why we have a fundamental principle of bicameralism, right? The states have a say, right? The only situation in which they don't have a say is if only money is being discussed, right? Because the people shall have control over the purse, right? So that is the idea behind money bill. So if only money, and what is a money bill? Article 110 says this is about money bill. If it is not a money bill, then the states have a say, and if any bill which is not a money bill is turned into a money bill, then the state's say could be ignored, right? You could just ram it through Lok Sabha and say like this is done, right? States don't have a say. So you now understand the importance of this. All right. So so let's look at Adhaar Act. So we figured what a money bill is. We figured what an Adhaar Act might look like for it to be a money bill. It should only deal with what we discussed here, if it only declares an expenditure to be charged upon the Consolidated Fund of India, right? So Adhaar Act has 59 sections. Section 7 is the important one. It refers to expenditure which is incurred from the Consolidated Fund of India. But so what does it say? It refers to expenditure which is incurred, not charged, incurred upon the Consolidated Fund of India, right? So why not charged, right? Is it the same? Like, what's the difference here, right? Significantly, the expenditure under the Adhaar Act is not charged upon the Consolidated Fund of India. So why is it not charged? It's because of clause 3 of Article 112. Right, what does it say? It prescribes all items that need to be charged upon the Consolidated Fund of India, right? So it says salaries or allowances of chairman, deputy chairman, speaker, deputy speaker, blah, blah, right? For example, if there is a judgment or award against the government, so it is charged upon the Consolidated Fund of India. Pensions of the judges, CAG, salary allowances are all charged upon the president on the Consolidated Fund of India. This is the relevant provision here. Any other expenditure that the Constitution declares, or if the Parliament charges on an expenditure by law. If the Parliament by law charges an expenditure on the Consolidated Fund of India, then that becomes a charged expenditure. And if that becomes a charged expenditure, then this becomes a money bill. And even then, even if it is a charged expenditure, even then the bill should only deal with this. It should only deal with the charged part, and that's it. If it deals with other issues, then it is not a money bill, right? So both these conditions are not satisfied. The first condition, that it should be charged upon the Consolidated Fund of India, is not satisfied. It is actually, the law says incurred, right? The second condition, that it should deal only with the charged part, no, that is not satisfied, because there are 59 sections, and like those deal with very significant parts. There are other significant parts of the bill, all right? So you understood this. Now, let's look back at the Adhaar judgment, right? That is important, all right? So the court has to justify that bill, Adhaar bill, as being money bill. So what did the judges say? The judges said it is a money bill. Why? Because there is a substantial nexus with the appropriation of funds from the Consolidated Fund of India and was directly connected with Article 110 of the Constitution. So what is the reasoning? What is the doctrine now, right? It is substantial nexus with the appropriation of funds, right? So the court said they're connected. This is connected. There is a nexus. There is substantial nexus. So it's a money bill, right? So this majority view which has been introduced, and this appropriation of funds and direct connection now is now the law, right? So what are the arguments against this view, right? So the biggest fear, as I've told you earlier, is that from now on any government can steer through the parliament, or any future parliament might label or might sort of incorporate a provision that incurs expenditure from the Consolidated Fund of India. And it could be a bill that deals with very random subject, let's say transgender people. And because there is this small element of charge or of expenditure being incurred from the Consolidated Fund of India, you can now call that a money bill and render Rajya Sabha obsolete. Right? You could completely tell the states that you have no say, it is just the House of the People. So there could be inter-house clash, right? The House of the People will say that the House of the States don't have a say and we will pass the law. This is the biggest problem that there is with this judgment, which is what the experts are pointing out. The experts have also said that the Adhaar bill is pretty much an ordinary bill, and on its best day it could be a financial bill category 2, right? So this is the context in which you should understand Adhaar judgment, and the story of the Adhaar judgment is not over. You will constantly get like articles about right to privacy and Adhaar judgment and all of this. So this is the context in which you should understand, and the question on money bill again is very important, all right? the parliamentary procedure through which you pass laws was again called into question when the 3 farm laws were passed by Rajya Sabha, right? So this parliamentary procedure is something that you should be very well versed with to actually analyze, right? If you don't know what the section, what the articles say, how are you going to analyze what the government has done, right? Or what the parliament has done, all right? So I hope you've understood this to the satisfaction of yourself, all right? So I hope you continue reading your newspapers and keep making notes, and if you don't understand anything here, put it in the comments. I'll be more than happy to answer, and take care of yourself. Bye bye.